So, the following marriages are void from the very beginning, okay? Void ab initio. So, where consent is lacking, there was no consent, okay? There was vitiated consent. There was force. There was intimidation. Next is contracted by any party who is not legally capacitated, okay? So, for example, the other party has a previous marriage. Next is solemnized by any person not authorized to perform marriages, okay? Next, solemnized without a valid marriage license, okay? Except those exempt from the license requirements. And then common law marriages and marriages by proxy, okay? They are void. They have no legal effect whatsoever. So, effect of defect or irregularity in the requisites. So, if any of the essential requisites is defective, marriage is voidable. Okay? So, for example, you've complied with the essential and formal requisite. Okay? However, there was a defect. Okay? Due to the previous requirements that you have not met. For example, the person applied for marriage, and then when he secured a sinumar, there was a previous marriage. However, the truth of the matter is that that person has already filed for annulment, and that the annulment was already decreed by court, that his previous marriage was annulled. However, that person did not file it to the registrar, okay, for record purposes. So, that is a defect, class, okay? Next, if there is irregularity in any of the formal requisites, so validity of marriage is not affected, but the parties responsible for such irregularity shall be civilly, criminally, or administratively liable. Okay? So, even though the requisites are there, but there is also irregularity. Okay? As to the formal requisite, then the person, okay, responsible can be liable. Okay? Next, marriage void ab initio where consent is totally lacking. Okay? So, like what I said earlier, consent is essential. So, absent of which will make the marriage void. Okay? And then marriage contracted through mistake of one contracting party as to the identity of the other. Okay? So, there was a mistake to the identity. Of course, it's like a vitiated consent. So that marriage is also void ab initio because there was no real consent. Where there is consent but same is vitiated by reason of fraud, force, intimidation, or undue influence, or either party is of unsound mind, then marriage is voidable because consent is defective but it is present. Okay? So, it is valid but it can be voided. Okay? Next is marriage celebrated without a valid marriage license. So, the effect is it is void from the very beginning. Okay? Void ab initio. A marriage which preceded the issuance of such license is void. Subsequent issuance of such license cannot render valid or even add an iota of validity to the marriage. Okay? So, even if you later on acquire marriage license, then you cannot cure the defect. Marriage celebrated 120 days after the issuance of a marriage license is void ab initio. Okay? So, marriage license class has a validity, okay? Has a lifespan. And it is only good for 120 days, okay? So if it expires, you need to secure another marriage contract, okay, or marriage certificate. Because if it expires and you still use it, then your marriage is considered void from the very beginning. Failure of parties to sign the marriage certificate will not likewise affect the validity of marriage. So the purpose of the certificate is it is evidentiary in character, okay? It is an evidence. It is the best evidence of a marriage. And then absence of marriage certificate is not proof that no marriage took place because other evidence may be presented to prove marriage. Okay? For example, marriage certificate is held in trust in PSA, okay? Philippine Statistic Authority. So, for example, PSA will be destroyed and then all documents will be lost. So, do not worry because there are still other ways in order to prove marriage, okay? For example, testimonial, okay, the affidavit of the solemnizing officer. Next, your witnesses, the affidavit of your witnesses, and so on and so forth. Next, Article 5 and Article 6. For a marriage to exist, it is essential that the contracting parties must appear personally before the solemnizing officer and that their consent to the contract of marriage be given in the latter's presence. Okay? That is why it is important to say the I do's in the presence of the solemnizing officer. Okay? So, the solemnizing officer will ask both parties in order to determine consent. Okay. So, husband A, do you accept your wife B as your wife? Okay. And then you will answer, yes, I do. Okay. Mere private act of signing a marriage contract without the presence of the solemnizing officer does not amount to a marriage ceremony. Okay? So, everything must be done in the presence of the solemnizing officer. Okay? The parties must be present. The witnesses must be present. Okay? In front of the solemnizing officer. So, 3 requisites in a marriage ceremony. There is personal appearance, there is personal declaration, and then the declaration done in the presence of the solemnizing officer, and at least 2 witnesses of legal age. Okay? Another important requirement for witnesses is that they are of legal age. Okay? 18 and above. Next is Article 7. Members of the judiciary. Okay? So, these members of the judiciary can also solemnize marriages. Okay? The requirements are, they must be incumbent members. Okay? They must solemnize the marriage within their court's jurisdiction. So, it is very important, okay, to know the jurisdiction of the court. For example, MTC or the Municipal Trial Court has limited jurisdiction compared to the Regional Trial Court, okay? And Regional Trial Courts has smaller jurisdiction compared to Court of Appeals or justices, okay? So it is important that you determine the jurisdiction of the court, okay? Because they can only solemnize marriage within their jurisdiction. So the following are members of the judiciary, okay? So the Chief Justice and Associate Justices of the Supreme Court. So their jurisdiction is anywhere in the Philippines, national jurisdiction. And then justices in the Court of Appeals, okay? And then the judges in the Regional Trial Court, Metropolitan Trial Court, and so on and so forth, okay? So they can only perform or solemnize marriage within their respective jurisdiction. So marriages outside the court's jurisdiction. So outside of their court's jurisdiction, they are not clothed with authority to solemnize marriages. Okay? So they don't have power to solemnize marriage outside their jurisdiction. So if marriage is solemnized by a judge of RTC outside of their court's jurisdiction, there is an absence of a formal requisite. So the marriage will be considered void from the very beginning. So there is a total absence of a formal requisite. Now, let's go to marriage in good faith under Article 35, paragraph 2. So if the good faith of the parties consists in their mistaken belief that a judge has the authority to solemnize marriages outside of his court's jurisdiction, marriage is void from the very beginning. So this is a case of ignorance of law. However, if their good faith consists in their mistaken belief that the solemnizing officer is a judge of the locality where the marriage is celebrated, then good faith may be invoked in the case since there is a clear case of ignorance of fact. Okay? So, now it is evidentiary class. Okay? You must present evidence that you are ignorant of the fact that the judge has no jurisdiction in that locality or has jurisdiction. Okay? So, it's like a mistake of fact class. Okay? However, it is a case-to-case basis and you need to prove it in court. Okay? So, another solemnizing officers are the priest, rabbi, imam, or minister. Okay? So, the issuance by the Civil Registrar General of the authorization is purely a ministerial duty. Pursuant to Article 33, marriages among Muslim or members of the ethnic cultural communities may be solemnized without need of securing a marriage license. Okay? So they have their own set of laws, especially our Muslim brothers and sisters. However, Article 33 does not dispense with the requirement of registration of the solemnizing officer. Next is a solemnizing officer in a city or in a municipality, okay, or the local government unit. So their authority was restored by the local government code, okay. Mayors. Ordinarily, the powers of a mayor are confined only within his territorial jurisdiction. But the fact that a mayor had solemnized a marriage outside of his jurisdiction will not affect the validity of the marriage. This is a mere irregularity in the exercise of his authority. Okay? So as a general rule class, a mayor can only solemnize within his territorial jurisdiction. So if he is a municipal mayor, he can only solemnize marriage within his municipality. Okay? However, if again there is a mistake of fact, it does not affect the validity of marriage. Okay? So different from the authority of the members of the judiciary, which is confined by law to their court's jurisdiction. The local government code states that mayors are authorized to solemnize marriages without limiting the exercise of such authority to their territorial jurisdiction. Okay? Next is Article 8, okay? Which discusses the venue or place of marriage, okay? So these are just matters of reading, class. It's in the files. I will leave this up to you. Okay? So Article 8 is merely directory. It only refers to the venue of marriage and does not alter or qualify the authority of the solemnizing officer. Non-compliance will not affect the validity of the marriage since this is a mere irregularity. Okay? But not in the case of marriages solemnized by judges outside their territorial jurisdiction. Okay? So, once again, ceremony, okay, during marriage is essential. That is why the venue is essential. Because if the solemnizing officer is a judge or a mayor, they must perform such acts within their territorial jurisdiction. Okay? Next is Article 9 and Article 10 of the Family Code. So if the license is obtained elsewhere, the validity of marriage is not affected since this is a mere irregularity. If the marriage is between a Filipino and an alien, okay, so by alien it means a foreigner, it appears that the consular officials are not clothed with the authority to solemnize such marriage. They have no authority to solemnize marriages outside of the country where they hold office. Okay? Next is Article 11 and Article 21. So application for issuance of license must be filed in the local civil register of the city or municipality where either contracting party habitually resides. Okay? So one requirement when you secure for a marriage license is that it is your habitual residence. Okay? It is a condition sine qua non. Okay? A condition precedent that you secure your marriage license within your residence. Although a license obtained elsewhere shall not affect the validity of the marriage. So, documents accompanying the application. So, here are the requirements in order to secure a valid marriage license. First is the birth or baptismal certificate, then death certificate of spouse, divorce decree, etc. if previously married. Okay? Parental consent, if absence of parental consent is a ground to annul marriage. Okay? Parental advice, certificate of marriage counseling, certificate of legal capacity. So the absence thereof is a mere irregularity. If the license is issued prior to the lapse of the 10-day period of publication or issued in the absence of such requisite publication, it will not affect the validity of marriage celebrated on the basis of the license so issued. Issuance of a license is a ministerial duty of the civil registrar. Okay? So, it is, their duty is ministerial. So, by ministerial, it means that it is part of their, they are duty bound to give the same. Okay? So, if they will not issue marriage license, even if you have submitted the requirements, then you can file a case in court, okay, in order to compel the local civil registrar to issue the same. So, Article 22 and Article 25 of the Family Code. So, marriage certificate or marriage contract is the best documentary evidence of marriage, okay? Like what I said earlier, the weight of evidence of a marriage contract is very heavy. It is considered to be the best documentary evidence for marriage. Okay. However, there are also other evidence which are not precluded by law. Okay. For example, a marriage certificate can't be secured. So, the affidavits of solemnizing officer can be used as evidence. The affidavit of your witnesses can also be used as evidence to prove marriage. Okay? So, the mere fact that no record of marriage exists in the registry of marriage does not invalidate said marriage as long as in the celebration thereof all requisites for validity are present. Next is Article 26. The following marriages are void from the very beginning, even if valid in the place where it was celebrated. So, the following instances are void or has no legal effect. If both parties are Filipinos and either one or both of them is below 18, okay? Like what I said earlier, the age of majority is now 18 years old and above. So if you are married and your age is below 18, then your marriage is considered void ab initio, okay? Void from the very start. Next, if one of the parties to a marriage is a citizen of the Philippines and he or she is below 18. Next, bigamous or polygamous marriages, okay? By bigamous or polygamous, it means that the one of the spouses or both spouses has already been previously married and subsequently remarried, okay, without the requirements of the law, okay. For example, the previous marriage was not dissolved, okay, there was no annulment. For example, the spouse only secured a divorce decree because here in the Philippines, class, divorce is not accepted, okay. So if contracted through the mistake of one contracting party as to the identity of the other, okay, there is mistake in identity. If one of the parties in the subsequent marriage is a party to a prior marriage which has been annulled or judicially declared void but fails to comply with the requirement of Article 52. Next, if one of the parties to a marriage at the time of the celebration was psychologically incapacitated to comply with the essential marital obligations, okay? So, psychological incapacity is the basis, okay? One of the basis for annulment of marriage, okay? So, when you want to annul your marriage, it must be factual, okay? You must prove it in court through evidence. Another void marriage are incestuous marriage, okay? Marriage between siblings, relatives within fourth degree. If void by reason of public policy, okay? So, it is a condition sine qua non, okay? A condition precedent that divorce must have been obtained by alien spouse and not by Filipino spouse, okay? So in the Philippines, divorce can be allowed if the one securing the divorce decree is the foreigner spouse, okay? Because for all intents and purposes, divorce for Filipinos, pure Filipinos, is not allowed, okay? So as enunciated in the case of Orbicido, Republic versus Orbicido, Supreme Court declared that Article 26, Paragraph 2 should be interpreted to apply cases involving parties who at the time of the celebration of marriage were Filipino citizens, but later on, one of them becomes naturalized as a foreign citizen and obtains a divorce decree. The Filipino spouse should also be allowed to remarry as if the other party were a foreigner at the time of the solemnization of marriage, okay? So, in the case of Orbicido, it was expounded by the Supreme Court that if your spouse, even though Filipino, who became a foreigner through naturalization and that spouse secured a divorce decree, then the Filipino spouse can remarry by virtue of that divorce decree, because the foreigner spouse, for all intents and purposes, is considered an alien. Okay? So the reckoning point is not the citizenship of the parties at the time of the celebration of marriage, but their citizenship at the time a valid divorce was obtained abroad by the alien spouse. Okay?